Hey everyone, Miranda Dressler here, attorney with the law offices of Bridget and Mackay in Petaluma, California, and we practice in the areas of estate planning and elder law. And today is the third part in my 8-part series on the 8 biggest mistakes that clients make after they've gotten their estate plan done. And so the third mistake is a really important one, and that is not maintaining the funding of your estate plan over time. Because with a trust, what the funding is when you transfer the title of your assets into the name of your trust. It's one of the most important aspects of getting a trust done, because until you've done that, really your trust has no authority over any of your assets. And because people generally get a trust done to avoid probate, right? That's one of the main reasons. But a trust isn't going to do that if your assets aren't in the name of the trust. And so this can happen innocently enough. For example, many people right now are refinancing their homes because interest rates are so low. And what often can happen in a refinance is the lender will require that you take title of your home out of the name of your trust and put it back into your names as individuals during the process. But unfortunately, many times the title to the house doesn't make it back into the name of the trust after the refinance is complete, and you're not aware of it. And so when you eventually pass away, that asset has to go through probate, which is something, as I said, you were trying to avoid in the first place. Because really the magic of how a trust works is how you hold title to your assets. Once you create your trust, you can think of it kind of as like a big empty chest. Until you transfer title of your assets into the name of that trust, the trust, as I said earlier, really has no authority over those assets. And any asset that's not titled in your trust when you pass away is going to have to go through some kind of probate process. Okay, so this is one of the most common mistakes that we see clients making. And I would be really surprised if, anyone out there who had a trust had a fully funded trust with every single thing, an asset that should have been in the name of the trust, in the name of the trust. So that is it for mistake number 3. If you have any questions, you should contact an experienced estate planning attorney in your area. Thank you.